away, please. Thank you. Cell phones off and away, please. Thank you. Mr. Barker?
Yeah.
Off and away, all the way away. Please.
Oh, wait, what do you mean?
Put it in your pocket.
Oh,
Thank you.
All right, this is case number 15 CF 627, State of Wisconsin plaintiff versus James A. Barker III defendant. Appearances, please.
Good afternoon, Haley Johnson for the state as a special prosecutor.
James Barker, defendant. Okay.
Thank you. Matters on the calendar today for a motion hearing. We have Mr. Barker's motion to dismiss, as well as motions to suppress filed by prior counsel. Before we begin, Mr. Barker, I'm going to hand to you, actually, Ann, if you wouldn't mind handing this to Mr. Barker. It's a waiver of right to attorney form, Mr. Barker. We've gone over it several times in the past. I have not had you sign it, though. I filled it out to the best of my ability, but I need you to go through it with me just to confirm that the information that I have handwritten here is correct. So in the caption is your name, date of birth, and the case number. The waiver of right to attorney then reads, I am asking the court to allow me to represent myself and give up my constitutional right to have an attorney represent me. I understand that if I choose to represent myself today, I may change my mind at any time during this case and may be given an opportunity to have an attorney represent me. I have 35 years old, is that correct?
36.
36 now? All right, we will change that. 36 years old, and I have completed 10 years of education, is that correct?
Graduated, yes.
Well, my understanding is that you do have an HSED, is that correct?
Correct.
Okay, so you have 10 years of formal education, but then you did go on to receive your HSED, correct?
Correct.
Okay. And so as we read further, it says I do have my HSED. When I filled this out, you are not presently employed. Has that changed, sir?
Nothing, yeah. No,
Okay.
No, I didn't change.
Okay, so you're still presently unemployed?
Yeah.
Okay. The next paragraph says, I do read, write, and understand the English language. I am not currently receiving any treatment for mental or emotional problems. I have not received treatment in the past for mental or emotional problems. I have not had any alcohol medications, whether prescribed or not, or drugs within the last 24 hours. I do not have any physical or psychological disabilities that may affect my ability to understand what is happening in court or to communicate my position or views on this case to the court. Is that all correct?
No, it's not.
What is incorrect, sir?
Due to the stress and anxiety that I'm going through for the last 2.5 years fighting this case, I can't tell you that far as the mental stress or capacity thing, so like I'm not signing any forms. I'm not in a position to sign. I made it clear on court. I made it clear on record at the last court appearance that I do want to represent myself, but I want an attorney sitting beside me because I have no experience at trial, and I don't know what, like, you get me to sign this paper, the statement, playing all kind of games with me. And I'm just not going to put my Hancock on nothing that I'm not
Well,
sure.
certainly, sir, if you want to retain an attorney to sit beside you, you can do that at any time. You've already been told that.
Well, I told you I cannot afford an attorney. I would like the state to appoint me an attorney, not to represent me, but just to, not to fully represent me, but just to sit beside me and make sure that I'm following the proper motion and using the proper court procedures, because it's apparent that the courts is going to be biased and not going to help me make the right decision and ensure that I'm not doing things that's outside the guidelines.
Mr. Barker, you've already been represented by Mr. Saldana. David Saldana, was he court appointed or was he a
No.
private pay?
Privately.
private pay? And then Attorney Mark Nielsen, before he became a judge, was he private pay or?
Private pay.
Okay. Attorney Laura Walker was a public defender appointment, correct?
That was an illegal appointment. Laura Walker was my co-defendant's attorney. I don't even know why they tried to give her appoint her as my attorney.
You are correct. She did indicate right away that she had a conflict and she was allowed to withdraw. But then Attorney Lori Keene was appointed by the Public Defender's Office, correct?
Yes,
All right. The Public Defender's Office then, after she filed a motion to withdraw, appointed Robert Bucket, correct?
yes,
And then the Public Defender's Office also appointed Attorney Patrick Ritter when you then privately retained Attorney William Sultan, correct?
I never met Ritter, never spoke to him. I never even knew he was my attorney until I got some documents from Sultan.
That's correct. And you may be correct about that because he was appointed by the Public Defender on August 25th of 2016, and you then privately retained Attorney William Sultan on September 1st within a matter of days, correct?
Correct.
Okay. So you've retained all of these private lawyers, including then, most recently in January of this year, Attorney Vincent Bobbitt. I know Mr. Bobbitt returned his retainer, correct?
Yes,
So why don't you have those funds to retain someone else, sir?
I did say that I am unemployed and I have to live. I currently can't get a job because I get drugged back and forth to court every month when I got my CDL, so I can't hit the road. So with that said, it's because of this case is the reason why I'm not employed. I did go to school since this been going on, and I earned my CDL driver's license.
All right, when did you earn your CDL, sir?
Huh?
When did you earn your
I
CDL?
earned my CDLs in April of this year.
And so far, you've not been employed as a driver?
The first year as a CDL driver, you must hit the road to gain experience and get miles under your belt before you can work local. So with the court dates constantly being scheduled every month, and I have to come down here to drive every month, there's no way that I can take a CDL job and be over the road, and when they can't guarantee you back home on a certain date. So I will probably eventually end up missing a court date, catching a bail jump, things like that. So I just can't risk it. But yeah, I have plenty of recruiters calling me that's looking to hire me, but I just can't accept the position right now.
So what are you saying? You're saying that you want me to once again have you reviewed for public defender representation, despite the fact that all of these attorneys have been appointed for you in the past, despite the fact that you then subsequently retained lawyers to represent you, but you don't want that person to do anything other than sit next to you at counsel table?
Yeah, that's possible. Just make sure that I'm following I'm following court procedure, which the state isn't doing, but this is basically a biased situation for me. And I mean, the state don't hand in, they send me, have me driving away to Walworth County, pick up discovery.
All right, let's not get off on tangents. Are you prepared to argue your motion to dismiss today?
Yes, I believe I am prepared to argue my motion to dismiss, but you also mentioned another motion that I'm not prepared to argue. That's my other attorneys obviously filed, but it hasn't been, the motion hasn't been brought forth to court, and I'm not honoring anything any of my previous lawyers have filed because they haven't filed a motion to compel, which was supposed to have been done first before any motion to suppress was done, even with Des Bobbitt on May 8th.
All right. If you are prepared to proceed with your motion pro se, then I need you to sign the form, sir. If you're saying you're not prepared to proceed pro se today, and you want to be evaluated to have an attorney sit next to you, well, I can make one last effort to do that, because we're getting very close to having this case scheduled for trial.
Well, it seems as if you get very impatient with me, but it's been 2.5 years I've been fighting this case. It has been 3 times that you have compelled the DA to give me all the discovery, so I can't move forward
Sir,
with this case.
I can't
unless-
even discuss the merits unless I'm satisfied you can proceed in representing yourself. And you're kind of talking out of both sides of your mouth today. You're saying, yes, I'm prepared to proceed today, pro se, but then you're telling me that you won't sign the waiver of right to an attorney form, and that you want me to appoint someone to sit by your side to make sure you follow proper procedure.
The last court appearance on June 30th, I believe it was,
June 30th.
I stated to you everything I just said now. I'm not confident, I do not want to represent myself without an attorney sitting next to me. And you told me that you're not going to allow me to have another attorney. You never told me that I needed to sign a waiver of rights form. I've been representing myself pro se, filing my own motions. It's on record that I'm representing myself pro se. And then I come to court and y'all put a form on my face and y'all want my Hancock, and I'm just not going to sign anything. Now,
Mr. Barker, if I sound frustrated, to a certain extent, I admit that I am.
Right?
Because I attempt to go over this information with you at every hearing. And when I get to the point about the crimes that you're charged with and the penalties, that's when you start telling me, I'm not good at math, suddenly you don't understand anything. So yes, it's frustrating. You filed a motion to dismiss that's an inch thick.
Right.
So I know that you can read, write, and understand the English language. You probably know this case better than anyone else.
Sure do.
Right.
So that's the reason why I don't need to sign it.
Well, but I need to make